All right, ladies and gentlemen, this is the Little Book on Legal Writing by Alan Dworsky, Chapter 7, Cases and Courts. Just a quick kind of heads up, Miyakizilla, we care about writing laws, but less so about practicing them in the court of law and stuff like that. So sometimes you're going to be getting a brief, kind of like, not a legal brief, a book brief, if you will. Anyways, refer to your case unambiguously. The phrase, "this case," is the simplest way to refer to your case, but be careful, it's easily ambiguous. It can be unclear whether this case refers to your case or to some case you recently cited as an authority. Then he goes into examples. Other ways to refer to your case are the present case, the current case, the instant case, the case at hand, and the case at bar. Our case is a natural way to refer to your case as an office memo, but you can't use it in a memo or brief to a court because first-person pronouns are inappropriate there. Interesting. Next, refer to decided cases efficiently. After you've given the full citation of a decided case, you generally should refer to it in your text by only the name or abbreviated name of the first party of that case. For example, after you've given the full citation for Fruth versus Gaston, you can then say, in Fruth, the court established a new rule. Don't say, in the Fruth case, or in the case of Fruth. Omit those needless words. There we go, that's pretty cool. Next, the court is, quote unquote, it. Even if a court has more than one judge, it is still a single entity. You should therefore use singular pronouns when referring to any court. Interesting. Make it clear which court you're talking about. If you refer only to the court when talking about a cited case, readers will assume you mean the court that wrote the opinion you're citing. But although readers can figure out which court that is from the citation, telling them in the name saves them work. So it's a good idea to name the court in full the first time you refer to it in connection with a case. That's kind of smart. Anyways, next. Remember which court you're talking to. Your appellate brief assignment may involve a made-up case, but the case may be set in a real jurisdiction. If it is, keep that in mind when you write your brief. If you're writing to the California Supreme Court and you're describing the Hill case decided by the California Supreme Court, don't say, in Hill, the California Supreme Court established a new rule, since you're writing to the same court that decided the case. You must say, in Hill, this court established a new rule. Treat made-up cases as if they were real. Be precise. Next, be precise in describing what a court did. Here are the precise words for several things courts do. Okay, so I think I'm going to crank through this. Okay. Grant or deny a motion, sustain or overrule an objection to evidence, accept or reject an argument, hold on an issue of law, find on an issue of fact, rule on an objection to evidence, motion, or issue of law, affirm, reverse, or modify a judgment or order of a lower court, vacate a judgment or order of a lower court, remand a case to a trial court, overrule precedent, uphold can be used synonymously for affirm in reference to the decision of a lower court. A court or judgment writes a memorandum or opinion to explain an order, judgment, or decision. Sometimes a court will even establish, enunciate, or articulate a new rule. Juries, not judges, return or hand down verdicts. Next, courts don't have feelings. Judges are human beings like the rest of us, whose decisions are often influenced by their emotions. But in our system of justice, judges are supposed to put their emotions aside and decide cases by dispassionately applying the laws to facts. Next, you rarely need to give the name of the judge who wrote an opinion. In case citations, you never need to give the name of the judge who wrote an opinion unless you're citing a concurring or dissenting opinion. Interesting. Next, use the past tense to describe everything about a case except the rule. The tendency to use the present tense when talking about cases arises understandably because a court's opinion, if it's still good law, is a living document. Its words, even if written long ago, still control the lives of citizens and the fate of litigants. Nevertheless, talk in the past tense about a court's saying or doing something. Very interesting. Next, compare apples with apples when comparing cases. This one gets super dense. I'm not going to go through it, but compare apples with apples when comparing cases. You're just going to have to maybe Google that one or something like that. It's too Dude, it's way too difficult to read. Anyways, next, cases are distinguished cases aren't distinguished until you distinguish them. You can't say case A is distinguished from case B. The cases are merely distinguishable until you actually distinguish them. So say case A is distinguishable or can be distinguished from case B, and then go to distinguish it. If a court has already distinguished the case for you, then you can say case A was distinguished from case B by that court. Cases are always distinguishable on countless facts, but only some of the distinctions have significance. Dude, I did not get that last one, but I hope you did. Anyways, remember, kiss that like button, kiss that subscribe button, and let's keep on rolling with some videos. All right, bye-bye. If you're an independent and you care about being represented, even more so if you're frustrated and you feel like you're not represented, the whole point of this project, the whole point of this content is to help independents feel like they've got a voice, feel like they've got somebody fighting for them. And so that's what this content's about. If you're interested in supporting this, go to the patreon.com/MiyakeZilla Patreon page and consider supporting us for $2 a month. That's all. All right, thank you very much. Bye.